There's the, holy cow, getting a loud reverberation. Am I breaking your ears out there? Sorry, I'll lean back. The Public Safety Judiciary House and Senate Conference Committee for the 92nd State Legislative Session will come to order. Members, I emphasize that just out of a bit of nostalgia. I've co-chaired 6 conference committees over my term here in the Minnesota Legislature. I've been on, I don't know, 10 or 12 of them, and this will be my last one. So I'm trying to dress this one up in terms of how we get started here today. Members, just a couple of housekeeping things. There is a quorum here. And welcome, Senator Osmek. Appreciate you being here. Oh, my video. There we go. Okay. First of all, just for you, Mr. Chair, I know that the Senate is going to be taking up a little bill this morning. So I'm wondering if you can just let us know how you intend to proceed through this hearing.
Thank you, Mr. Chair. Yes, there is an ongoing bill that will be heard starting at 10:30 today in the Minnesota Senate Chamber. The tax bill is being discussed, and we know that always is one that gathers a lot of discussion and a lot of amendments, and so it'll be a busy day there. We will be trying to follow that proceeding, and hopefully we can vote electronically while we're doing it. If there's a digital problem, we may have to leave, but that's our initial plan. I did want to bring one thing up, Mr. Chair. We have a copy of your agenda for today, but I have an issue. And the issue is we got that from, we received it, it was sent from your staff at 9:06 a.m. today. And that just is not acceptable for the Senate to get your agenda. We try to put our agenda ahead of time, but quite honestly, Mr. Chair, I don't know how we can have adequate discussion and meaningful dialogue when we have such a short range of having it. And we're going to be talking a lot about transparency in the next few days regarding criminal justice activities. And transparency is vitally important for a democracy. We need to have transparency. The public needs to have transparency regarding what our agenda will be as we go forward. 9:06, 6 minutes after the scheduled time for a committee to start, just is not acceptable. So I hope we can change that pattern in the future, Mr. Chairman. I understand there's bureaucratic bugaboos that happen, and sometimes you can't get everything put together, but we've had a long time putting the bill together, both you and I, in our respective chambers, and I think we can work a little bit on making sure that the public knows what we're going to be talking about in the upcoming days.
Well, thank you, Mr. Chair. Appreciate that. Your comments and your desires are publicly noted. I will say that I think the public is well aware that what we're doing here is that we're conferring both the Senate and the House Public Safety and Judiciary bill, which has been transparently published for several weeks now. But we certainly will accommodate the Senate's need and desire to have as much information as possible. The purpose of these hearings is, in fact, to have public conversations and about our bills and to exchange ideas as well as to make motions so that we can put together a bill as expeditiously as possible. And so that's my commitment. It's a commitment of the House, no doubt it's a commitment of the Senate as well. I look forward to us actually spending time being very constructive in terms of doing that. Let me just very quickly walk through for the members what the chair is expecting us to do today. Just as we had a walkthrough of the Senate bill yesterday, we will do a side-by-side walkthrough of the House bill. We will then have some discussion on that. My intention then is for us to be able to focus on immediately Judiciary Committee highlights in the House. This bill comes together as a result of two independent or freestanding committees, I should say, the Public Safety, Criminal Justice Foreign Committee and Judiciary and Civil Law Committee chaired by Chair Jamie Becker-Fenn, who is on this conference committee. So we're going to begin by doing, after the side-by-side, a focus on the Judiciary Committee highlights. Chair Becker-Fenn in particular wants us to focus on some of the civil legal services provisions, and at that point I'll just have her quickly describe what we're going to do there. Then we're going to shift over to the Public Safety Committee highlights. It was my intention originally to spend an entire committee hearing doing that particular part this Friday, but after receiving the unfortunate news that the majority of our Senate conferees will not be present for our regularly stated time this Friday nor Saturday, because they're going to be attending a partisan convention at that time, but yet still committed to making sure that we're moving effectively forward. I'm basically truncating what originally would have been a much longer conversation, Judiciary and Public Safety, and try to do that all here today. And so following that then, we'll do some highlights of some Public Safety Committee. We'll hear from the BCA as a part of that. We will then move into discussions, and then we will close out by having the House move I think it's four, maybe it's five, provisions for vote to begin the process of building our bill together. These are all Senate provisions, and so it's certainly my desire that we're not doing anything that's controversial, but actually quite constructive and effective in putting together the bill that we only have less than 2 weeks to put together for final consideration of our respective bodies. So with that, let me just do a very quick opening statement about the House bill. I'll try to keep this as short as possible, but I really want to just set the tone and the broad framework of the House bill. The House Public Safety Judiciary bill is a balanced approach to responding to the immediate challenges our state faces on public safety, something Minnesota shares with all other 49 states as we emerge from a worldwide pandemic that has so impacted and restructured our personal and community lives in our nation. The House bill comes from wide engagement with Minnesotans from throughout the state, officials and citizens in greater Minnesota and from the Twin Cities. We heard from victims of crimes, law enforcement, local electeds, and service providers working with youth. Most were on-the-ground people. We also heard from Minnesota and national experts on what the best research tells us about true public safety, that is, effective public safety, that it takes using a number of tools, not just one tool, a number of tools to break the cycles of violence and harm in order to keep us safe. So while not always popular to say, I'll be the first to say this bill says that police, in fact, do matter. But they aren't the only tool that matters. The bill says community interventions matter, but they aren't the only tools that matter. It says corrections work that is designed to break harmful behavior matters. It says that supporting victims matter, but support means helping them to rebuild their lives so that they can contribute to breaking cycles of harm. And it all matters all over Minnesota, not just in one community like Minneapolis, all over Minnesota. We pulled crime data from across the state and found that violence is a big, unfortunate reality in greater Minnesota as it is in our big cities. We mapped out, we actually have maps. We mapped out crime trends, and half of the communities experiencing growth in violence are in greater Minnesota. That means our response needs to be about building a stronger house that can support every community in Minnesota. We especially make sure that many of our responses don't bypass small populations, small tax-based communities. We design state investment to make sure all citizens will benefit from state appropriations, all citizens. like, for example, the opioid intervention appropriations that we target for greater Minnesota, adding $10 million to that intervention prevention fund. The bill focuses on 4 big areas: innovating public safety, to do big things, to help Minnesota be safer, to do better, to do new. Provide resources for victims, survivors of crime. Provide resources for youth interventions. Provide resources for our community corrections to be able to do their work and to do it better. And of course, there are lots of other issues that are covered, especially in Judiciary, with public defender appropriations that match up with the Senate's desire. The House bill shares much in common with the Senate bill if we want it to. So let's build what needs to be built in this special moment when we have the resources to do it and when the need for public safety is here right now. So members, with that, I'm going to ask Mr. John Walsh. I think you'll be starting, is that right? The side-by-side walkthrough of our spreadsheet, and then I'll ask our legal counsel to do our policy walkthrough as well. I certainly would defer to my staff of what the appropriate order is, but I think that's typically how we've approached things. And so with that, Mr. Walsh, if you could do us the honor of walking through the side-by-side here with the House.
Mr. Chair, for the record, I'm John Walls, House Fiscal Analysis, and I'll begin the spreadsheet at the top of page 1. Spreadsheets should be in members' packets. In the Supreme Court, the House included provisions that were part of the Is that better?
If you could pull your mic closer, yeah, that would be great. Thank you.
Mr. Chair, the House bill includes several provisions that were recommendations of the governor, including judge and employee compensation with 6% for judges. That is $2.3 million per year. A civil legal services salary increase, that is $4.3 million per year. Civil legal services COVID response, $7.4 million. A cybersecurity request at the Supreme Court at $1.75 million per year in ongoing funding. And House File 2739, which was increased funding to meet unmet need at civil legal services. This is $47.9 million in fiscal year 2023 and increases to $58.8 million in fiscal year 2024. Under the Court of Appeals, we include from the governor's request judge and employee compensation with 6% for judges at $621,000 per year. In the district courts, we include the judge and employee compensation with 6% for judges. That is $14.8 million per year. Also included is a request to make permanent last year's increase for interpreter pay. That is $200,000 per year beginning in fiscal year 2024, and a provision for mandated psychological services to the district courts of $1.996 million per year. Moving to the Guardian Ad Litem Board, we include a governor's request of $909,000 per year to maintain core operations. Under the Board of Public Defense, we include the requests for electronic file storage and remote hearing access at $627,000 in fiscal 22. This is a one-time provision. We include a salary equity increase of $1.1 million in 22, $2.2 million in 23, and ongoing. The House bill includes House File 833, a provision for post-conviction relief at $187,000 one time in fiscal 23. House File 2738, which is increased services and staffing at the Board of Public Defense at $50 million per year beginning in fiscal year 23. Moving down to the Department of Human Rights, the House includes several governor's requests. Improved caseload processing, $492,000. Bias and discrimination data gathering and reporting, $388,000. Bias response community equity outreach, $1.1 million. Equity and Inclusion Strategic Compliance, $228,000, and a one-time request for a consultant for Equity and Inclusion Strategic Compliance at $250,000 in fiscal year '23. Mr. Chair and members, on line 57, the House establishes an appellate council, a board of appellate counsel for parents that includes $699,000 in fiscal year '23 and $1.8 million in ongoing funding beginning in fiscal '24. That brings us to the Department of Public Safety. In Homeland Security and Emergency Management, we include the governor's request for a first responder wellness office, $2 million in fiscal '23 with $1 million in ongoing funding. We include some emergency management readiness grants at $1.5 million per year, and this is ongoing funding. We include $500,000 on a one-time basis for multi-agency response training, and a provision from House File 4168, Supplemental Security Grants, $225,000 in one-time funding in fiscal year '23. Moving down to the emergency communication networks, the House bill includes a provision from House File 2821, a public safety radio grant of $1 million to local communities. This is from the general fund. And on line 89, communicator certification and education. This is from the special revenue fund that comes from E911 funds. $1.45 million per year in fiscal '23 and $1 million a year ongoing. Under the Bureau of Criminal Apprehension, the House includes part of the governor's request for Violent Crime Reduction Support Initiative at $1.7 million per year. The House bill includes the governor's request for cybersecurity upgrades of $2.3 million in fiscal '23 and $900,000 in ongoing funding, and also includes $186,000 for a commission on accreditation for law enforcement. Also included are two provisions from House bills. The first is House File 1355, marijuana penalties modified. There is some money for a forensic scientist at $208,000 the first year and $191,000 ongoing. And provision from House File 1152, the Clean Slate Act. This is $1.1 million in fiscal year '23 and $520,000 in fiscal year '24. Mr. Chair, moving down to the Office of Justice Programs, this is where the House will have many provisions from a comprehensive package, which was House File 4200, but we include from the governor's requests the Office of Justice Program investment. This is for new staffing at OJP. $3.6 million per year is included in the House bill. We have $500,000 in ongoing funding for youth development grants. We have a governor's request of $1 million a year for general crime and trauma recovery funding. And the House includes $1 million a year for dual status youth model grants at $1 million per year. And this is from a newly created special revenue fund that the House creates with some revenue. Mr. Chair, moving down to the community-based public safety grants, the House includes $1.9 million in fiscal '23 with $75,000 in ongoing funding. We have in the alternatives to juvenile detention conflict resolution centers, the House funds two of those centers at $1.4 million per year, and also includes $1 million a year in ongoing funding for the Minnesota HEALS program. On line 120, the House includes $25,000 a year for prosecutor training, and then the bill moves into several provisions that come from House bills. The first was a provision from House File 861, direct assistance to crime victims, $4 million in 2023 and $2 million a year ongoing. Then we have House File 2959, combating sex trafficking, $1.5 million per year. We have a provision from House File 2668, which provides EpiPens for local law enforcement at $1 million a year. We have House File 2849, the Office of Murdered and Missing Black Women and Girls at $500,000 per year. House File 3055, an Indigenous Investigations Reward Fund at $110,000 per year. Then we have Youth Intervention Grants, $1 million on a one-time basis, which was from House File 2701. From House File 2958, a Substance Abuse Task Force at $144,000. Then we have a few categories of youth justice grants. We have youth justice prevention grants, youth justice grants for prevention of crime, $1.6 million from the general fund and $150,000 a year from the newly created special revenue fund. We have youth justice grants intervention, that is $2.5 million a year. We have House File 4397, Youth Wellness Support and Mental Health, $1.75 million per year. And Juvenile Wellness and Justice Task Force at $150,000 in fiscal year 2023. Moving down to the provisions from House File 4200, we have co-responder grants at $10 million per year. We have local community innovation grants, $55 million in 23 with $30 million a year in ongoing funding. We have House File 4200 emergency community safety grants at $15 million in fiscal 22. We have local community policing grants at $15 million in 2023 and $10 million per year in 24 and 25. And we also have local investigation grants, $15 million in 2023 and $10 million in 24 and 25. Moving to the State Patrol, there are two provisions in the House bill that come from different House files. The first is House File 1355, marijuana penalties modified. That is $168,000 a year from the Trunk Highway Fund. And from House File 1152, the Clean Slate Act, $84,000 in fiscal 23 and $168,000 ongoing. Which finally, in the Department of Public Safety, brings us to administrative services. From House File 4200, we have $6 million a year for body camera data storage. We have $9 million in 23 and $4.5 million ongoing for body camera grants. And House File 2867, soft body armor reimbursements. These are for first responders other than law enforcement at $1 million per year ongoing. That moves us down to the Post Board. We have a governor's request of $165,000 for a database for public records. Then 3 additional House provisions, $50,000 from House File 4200 for an alternative courses task force. We have House File 3785, strength and agility standards for law enforcement, $250,000 per year. And another provision from House File 4200, additional investigations staffing at the Post Board, $1.25 million per year ongoing. In the Private Detective and Protective Agents Board, we have a governor's request for a record management system and background checks. That's $100,000 in this biennium. We have additional money for investigate complaints and conduct field audits, $430,000 per year. And we have an annual review of the training curriculum at $70,000 per year. Mr. Chair, that brings us to the Department of Corrections. Under incarceration and pre-release services, the House bill funds governor's request for family support at $280,000 per year, maintaining family connections at $1.5 million per year, post-secondary education and employment, $2 million in 23 and $3.5 million ongoing, body-worn cameras at $1.5 million in 23 and $1 million of ongoing funding. There are also 2 additional provisions from the House bill that have a bed impact at the Department of Corrections. The first is violations of qualified domestic orders. There's a $10,000 additional bed impact in this biennium. And from House File 1355, reduced marijuana penalties, there's a savings of $38,000 in the first year and an increased savings in the ongoing years. Under Community Supervision and Post-Release Services, we have an increase for county grants, which includes $10,450,000 in 23, $25,750,000 in fiscal year 24, and increasing to an additional $38,300,000 to counties in fiscal year 25. We have provided a grants management system at $450,000 per year, Healing House Model Project and Design at $150,000 per year, expansion of work release at $1 million per year, and moving down to organizational, regulatory, and administrative services within the Department of Corrections. The House has fully funded the department's request for a public safety data infrastructure, $12 million in this biennium and $35 million in the tails biennium. $230,000 per year is included for project management, an increase for property insurance costs at $650,000 per year, an indeterminate sentence release board at $40,000 per year, and an aiding and abetting felony murder task force, that is misspelled, at $50,000 in fiscal year 2023. We included the governor's request for Ombudsman for Corrections. It's an information technology request, $33,000 for the biennium. And then we have some House provisions from other House bills. To the Office of Higher Education from House File 4200, use of force training, $2.5 million per year ongoing. We newly create a Board of Clemency from House File 3464, that is $705,000 per year. And increase funding to the Attorney General. This was both the governor's request and in House File 3702. The criminal enforcement funding would be $1.8 million a year beginning in fiscal year 23. Under sentencing guidelines, we have House File 1369, a charging data task force, $117,000 in 23 and $121,000 in fiscal year 24. Under revenue adjustments and transfers, we have some revenue from a private detective management system. This was part of the governor's request and creates $2,000 of revenue in 23. House File 2257, there's a reduction or an increase in the percentage that Ramsey County would keep from fine revenue to be on par with Hennepin County. This creates a loss to the general fund of $114,000. There is a revenue loss from the removal of charges for uncertified copies. This was from House File 3920. That is a loss to the general fund of $362,000. We have a transfer from House File 4200 from the general fund to the opiate epidemic response fund. That is $10 million one time in fiscal 23. We have a transfer from the MinCorp fund to the general fund of $7 million. We have some increased revenue to the Family Resiliency Partnership coming from the general fund and flowing to that partnership of $514,000 beginning in fiscal 24. There is a revenue loss from driver license reinstatement from reduced marijuana penalties in House File 1355. That is a loss to the Special Revenue Fund of $14,000 per year. And we increase the Red Wing per diem cost to counties, which creates $2.6 million per year, which flows to a newly created special fund which paid for some things that were previously mentioned that went to youth violence and crime prevention in the House bill. The total general fund impact, the House spent $340 million in the current biennium and has tails of just under $620 million. And Mr. Chair, that completes the walk through the House spending provisions.
Thank you, Mr. Waltz. Appreciate that. Members, quick timeout, or not timeout, Stepping aside for a second, I've just been notified we've gotten some information came in from the public. Just so folks know that, you know, both bodies are constantly posting, for the sake of transparency, posting on our websites information that the public sends in. It could be letters of support, letters of concern, you know, statements, et cetera. So there's a couple more that will be posted as we go through this hearing, and I've asked my committee administrator to hand out physical copies of those who are presently here. With that, members, let's go over to our House nonpartisan legal staff to walk through the policy provisions of the House bill. And I don't know who, yes, please.
Mr. Chair, it's Ben Johnson from House Research. I'm going to walk through Articles 2, 3, and 4 of the House bill before asking that you turn it over to recognize Mr. Diebel.
Very well. Thank you, Mr. Johnson.
So starting with Article 2 of the House file, I am going to refer to the page and line numbers from the House bill as we walk through. So Article 2 begins on page 24, line 21 of the House bill. Sections 1, 15, and also 27 to 30 are all policy provisions related to direct wine shipments. Section 2 makes a change in the Chapter 13 data provisions related to body-worn cameras that establish timelines for law enforcement agencies to disclose certain body camera recordings. Sections 3, 4, 9, and 32 require the Commissioners of Corrections and Public Safety and both the Sentencing Guidelines Commission and Post Board to prioritize public safety and human rights when implementing their missions and duties. This takes us to Section 5, which is page 29, line 13. Sections 5 through 8 are all from the Department of Public Safety Policy Bill. Section 5 modifies the requirement for county attorneys to provide victim notice in civil commitment proceedings to those victims who have submitted a written request to receive notice. Section 6 makes a conforming change related to the Section 5 change. Section 7 clarifies that the
Mr. Johnson, if I may interrupt, I apologize to you. We've got some members who are wondering whether we're following the side-by-side. Can you just clarify for us? I know that part of it is that you're moving around because you've got certain sections that you've identified early that you're the specialist, if you will, so you're focusing on those particular. But if you can just provide some clarity for us on this end in terms of how and what you're moving through, again, I'd appreciate it.
Yeah, Mr. Chair, I'm sorry if my initial explanation was unclear, but I'm walking through the House bill. I'm in Article 2, and my references are to the House page and line numbers. If members are looking only at the side-by-side, it is Article 2 of the side-by-side, and I'll reference the page and line numbers from the House bill, which are on the left side of the Article 2 side-by-side. So
hold on, Mr. Johnson, if you could just for a second. So, Mr. Johnson, we have a bit of a technical difficulty in that the members here don't have the House bill. What they've got is a side-by-side. I know, I'm wondering if it's possible for you to follow that format instead. And I know I'm throwing you a big curveball here. But is that something that could be readily done?
Mr. Chair, we're in Article 2 side-by-side, which is the same as Article 2 of the House bill.
Okay.
So the page and line references that I'm making are to the House page line numbers, which are on the left side column of the side-by-side. So if members look at the side-by-side Article 2, they can find the page and line numbers that I'm referencing going down the left side column. I'm afraid that I was initially told that we were walking through only the House bill and did not know that that members would only be provided with the side-by-side. So I don't have the R page numbers handy. However, the page line numbers that I'm referencing are all on the left side of the bill, and I'm generally walking through Article 2 in order at this point.
Very well.
So I'm in Article 2 side-by-side. If members look at the left side side-by-side, they're looking for the House language. I'm on Section 7, which is line 31.3 of the House language. So Article 2 side-by-side, left side, line 31.3. That's Section 7 of the House bill.
That
This
should,
is a portion of the Department of Public Safety policy bill.
so that should
Mr. Chair,
orient
is that-
us well, members, making sure everyone's on the same page here. All right. Very well, Mr. Johnson, please proceed.
So again, page 31, line 3 of the House bill, so line 31.3 of the Article 2 side-by-side. This is from the Department of Public Safety policy bill, and this particular section clarifies that the Office of Justice Programs and not the Department of Corrections is the designated agency responsible for domestic abuse funding. The next section, which is line 29.17, requires the commissioner to submit an annual report to the legislature. This is the Commissioner of Public Safety, including a list of reports that the commissioner is obligated to submit to the legislature. This has been referred to the report on reports. I'm moving now to Section 10, which is line 32.12 of the House language. This authorizes firefighters and qualified emergency medical service providers to participate in the state's soft body armor reimbursement program. Currently, only peace officers are eligible to participate. Sections 11 through 13, beginning on line 33.17, are all from the Department of Public Safety policy bill. Section 11 changes the name of the chemical assessment teams to hazardous materials response teams. Section 12 directs the Commissioner of Public Safety to consult with his or her agency when preparing the statewide hazardous materials incident response team. Section 13 removes an obsolete term. Mr. Chair, this brings us to Section 14 of the House language. This is line 35.1, again on the left side of that Article 2 side-by-side. Section 14 establishes a Public Safety Innovation Board within the Office of Justice Programs and defines the office's duties. This is from House File 4200. Section 15, again, is part of the direct wine shipment provisions. Sections 16 and 17, beginning at line 37.26, are both conforming changes related to a change in definitions in relation to labor trafficking. Section 18, we're at line 38.25, creates a reward fund for information on missing and murdered Indigenous relatives. The next section at line 40.14 establishes the Office for Missing and Murdered Black Women and Girls. Section 20, line 43.25, directs the superintendent of the BCA to provide an annual report to the legislature on the Fusion Center. Section 21 is another portion from the Department of Public Safety's policy bill. This section creates a questioned identity statute in Chapter 299C to codify the BCA's current process on how a person can challenge data contained in the BCA databases that is wrongfully associated with the person's name, and identifies the steps the BCA must take to disassociate wrongful information from a person's file. Sections 22 through 24, this is beginning at line 46.13, make changes to the access requirements for the Criminal Justice Data Communications Network and the Criminal and Juvenile Justice Advisory Group. Mr. Chair, that takes us to Section 25. This is line 49.6. Section 25 changes references to smoke detectors from smoke detectors to smoke alarms in statute. Section 26 requires the Board of Private Detective and Protective Agent Services to accept proof of the required pre-assignment training from employees of licensed private detectives and protective agents if the training was provided by another Minnesota license holder within the past 3 years. It also requires license holders to provide a certificate of pre-assignment training to employees even when the license holder paid for the training. Sections 27 through 30 I identified earlier. These are the direct wine shipment provisions, which brings us to section 31. This is line 56.12 of that side-by-side. Section 31 defines the term public safety telecommunicator for the purpose of the Minnesota statutes. The following section requires public safety telecommunicators to be certified by the Commissioner of Public Safety by August 1st of 2024 and provides details on that certification process. Section 33 authorizes the use of the 911 fee proceeds to fund that training, certification, and continued education. Section 34, we're at line 58.25, expands the list of qualified domestic violence related offenses to include first-degree manslaughter, second-degree manslaughter, kidnapping, and false imprisonment. Sections 35 through 39, that's beginning at line 59.11, amend the definitions and crimes related to labor trafficking. That takes us down to section 40. Section 40 is at line 61.14. This section establishes a gross misdemeanor penalty for the use of any device to observe, photograph, record, amplify, or broadcast sounds or events with the intent to capture an image of a private area of an individual without the person's consent and with the intent to intrude upon or interfere with the privacy of the person. Mr. Chair, this is a relatively new provision adopted on the House floor in reaction to a very recent state Supreme Court case. Section 41 is at line 63.9. Section 41 and 42 are, again, from the Department of Public Safety Policy Bill. Section 41 defines the term data for purposes of the state's computer crime statutes, and Section 42 expands the list of computer-related criminal conduct to include the unauthorized use and retention of computer software and data. Section 43 requires the Post Board to prioritize public safety and human rights. Section 44 at line 65.19 permits law enforcement officers to attach a mobile tracking device to stolen vehicles without prior court approval if the owner of the vehicle either grants consent or reported to law enforcement that the vehicle was stolen. Section 45 amends the statute of limitations for the crime of surreptitious intrusion. Section 46 at line 67.18 and also sections 47 and 48 are all again from the Department of Public Safety Policy Bill. Sections 46 and 47 clarify that the Office of Justice Programs, not the Department of Corrections, is the designated agency responsible for domestic abuse funding, and Section 48 removes an obsolete term. Section 49 at line 69.14 contains edits to the Hometown Heroes Assistance Program, which the legislature enacted in 2021 to provide services and financial support to firefighters. Section 50 established a task force that includes professionals and youth to examine the juvenile justice system and submit a report to the legislature. Sections 51 through 55 are the grant programs from Representative Frazier's House File 4200. Section 51 is at line 73.28. This one is the Emergency Community Safety Grant. These are made available by July 15th and are awarded for crime prevention programs, and they're awarded on a first-come, first-served basis. Section 52 at line 77.1 is the Local Co-Responder Grant. These are grants to cities, towns, and tribal governments, and also law enforcement agencies for embedded social workers, mobile crisis teams, or violence interrupters who work with law enforcement agencies. At line 78.3, the local community innovation grants are grants to cities, towns, and tribal governments with high rates of crime or rapid increases in crime rates. And the grants are for programs designed to reduce crime. Section 54 at line 81.18 is the local community policing grant. These grants are for programs designed to reduce crime by increasing the capacity, efficiency, and effectiveness of law enforcement community policing efforts. Section 55 at line 84.17 is the local investigation grants. These are grants for programs designed to reduce crime by increasing the capacity, efficiency, and effectiveness of law enforcement investigations. The final section in Article 2 is Section 56. This is at line 88.1. This is a repealer. There are 3 portions to the repealer. It repeals the crimes of sodomy, fornication, and adultery. Also repeals the definition of blackmail, which was amended in the provisions related to the labor trafficking statutes. And it also deletes an obsolete term, the Regional Hazardous Materials Response Team. Mr. Chair, that completes the walkthrough of Article 2. If members are prepared, I'll move to the walkthrough of Article 3. This is the side-by-side House Article 3, again with references to the left side, which will have the page and line numbers from the House bill.
Yes, Mr. Johnson, and thank you for making sure that we're properly tracking. It's very helpful, and I do apologize for the confusion, but I think we're all in sync here. So thank you. Please proceed.
So Article 3, again, this is the Article 3 side-by-side, looking at the left side, which contains the House language. My references will be to the page and line numbers on that left side. Section 1 is at line 88.8. This permits, rather than requires, the Post Board to order a law enforcement agency to conduct an inquiry into a written statement or complaint that alleges a violation of a statute or rule that the board is empowered to enforce. Section 2 eliminates the statute of limitations in civil cases involving an alleged sexual assault by a peace officer or an allegation that a peace officer caused the wrong, just the sexual assault provision. Section 3, which is at line 89.10, amends the statutes of limitation for an allegation that a peace officer caused the wrongful death of another, such that the suit must be brought within 6 years of the time the county attorney declines charges or a criminal proceeding ends. Both sections 2 and 3 permit individuals who are not currently able to file suit due to expiration of the limitations period to bring a suit provided they do so within 5 years. Section 4, which is at line 90.12, requires state law enforcement agencies participating in a joint response to certain major public safety events to appoint a compliance review officer. Section 5 requires law enforcement agencies to use only scientifically content-validated, job-related physical strength and agility screening exams for peace officer applicants. Section 6 at line 91.17 directs Post to adopt rules under Chapter 14 that permit Post to take action on a licensee for a violation of a standard of conduct, whether or not criminal charges have been filed. Section 7 adds additional requirements that must be included in body camera policies adopted by law enforcement agencies that have officers who use portable recording systems. Section 8 at line 93.25 authorizes local units of government to establish civilian oversight councils and grant an oversight council the authority to make findings of fact and impose discipline on officers. Section 9 at line 95.1 provides that the Leech Lake Band of Ojibwe has concurrent jurisdictional law enforcement authority with the local sheriff within the boundaries of their reservation, regardless of whether a cooperative agreement exists, provided the law enforcement agency meets the requirements set forth in Minnesota Statutes section 626.93, subdivision 2. Section 10 at line 95.9 amends the appropriation of $6 million to reimburse peace officer training expenses to limit the use of appropriations to training courses that qualify for reimbursement under either section 626.8469, which is training in crisis response, conflict management, and cultural diversity, or section 626.8474, which is autism training. Section 11 at line 97.1 establishes a task force to increase recruitment of new peace officers. Section 12 is a title provision. This provides that the sections relating to amending the civil statutes of limitations for certain actions committed by a peace officer may be known as Justin Teigen's Law. Mr. Chair, that is the end of the Article 3 walkthrough. I'm going to move to the revisor side-by-side for Article 4. This does have some Senate provisions on the right side, but again, I will be referencing the left side, which is the House language. My references will be to the page and line numbers from the House bill. Mr. Chair, I will be bouncing around a tiny bit because much of this is from one bill, but it's spread out throughout. So Section 1, which is page 99, line 5 of the House language, sections 1 to 3, and also sections 5 to 14 and 16 to 21 are all from House File 1355. Those provisions make multiple changes to the marijuana laws in the state, including adding some forms of non-flower marijuana to the definition of a small amount. They create a new gross misdemeanor offense for certain first-time offenders. They provide for expungement for certain convictions and provide for restoration of the right to possess firearms following an expungement. Mr. Chair, that's going to bring me to Section 4. Section 4 is line 99.22. This is entitled Park Zone, and it amends the definition of park zone in the Controlled Substances chapter to include public parkland designated by a federally recognized Indian tribe. Again, I'm going to move past sections 5 to 14, which are from the marijuana provisions. And I'm going to move down then to section 15. Section 15 is at line 105.30 of the House language. Again, section 15, line 105.30 of the House language. This section prohibits a court or the Commissioner of Corrections from preventing a person from participating in the medical cannabis program as a condition of release. Also prohibits revoking a person's release for participation in the medical program or considering the person's participation in the program when imposing penalties for violations of conditions of release. Mr. Chair, again, the next several provisions are from the House bill addressing the marijuana penalties, which means I'm going to move to the final section in this article, which is section 22. That's page 110, line 24 of the House language. Again, section 22, line 110.24. This is a task force provision. It establishes the task force on abuse of controlled substances to review the ways in which the state's justice, social service, and health systems respond to substance abuse issues and examines the approaches taken in other jurisdictions. It directs the task force to make policy and funding recommendations to the legislature. Mr. Chair, that completes the walkthrough of those 3 articles. I'd ask that you recognize Mr. Diebel to continue with the public safety provisions.
Very well. Again, thank you, Mr. Johnson, for carefully walking us through those provisions. Mr. Diebel.
Morning, Mr. Chair, Chair Limmer, members. Can you hear me okay?
We can indeed, sir.
Okay, very good. I'll begin with Article 5, which is entitled Corrections and Sentencing. The side-by-side you'll note is only has the House provisions. There are no comparable Senate provisions. And so any sections I refer to are the House positions. The article consists of 5 major pieces of legislation that would take up about 85% of the body of the article. The first begins in Section 1, which is entitled the Clean Slate Act. And this establishes an automatic expungement process for certain offenses. That's Sections 1 and 2, as well as Sections 17 through 26. and those are on R11 and R22 of the side-by-side. Sections 3 through 6 are another major piece of legislation in this article. It's juvenile delinquency process reform, and it affects the age of delinquency, moving it from 10 to 13, and prohibits the certain searches of juveniles as well as prohibiting the use of disciplinary room time. That's on R2 and 3 of the article side by side, as well as sections 15 and 16, which can be found on R8 through 11 of the side by side. Section 7 of the side by side is a provision from the Department of Corrections which requires them to make certain that information that's distributed to inmates is accessible to those who speak languages other than English. Section 8 on R3 of the side-by-side requires that the ombudsperson for corrections only be removed for just cause. Section 9 on R4 of the side-by-side requires counties pay 100% of juvenile detention costs when juveniles from their county are placed at the correctional facility at Red Wing. Another major piece of legislation in Article 3 is creation of an indeterminate sentencing release board. This is sections 10 and 11 of the article, and that is found in R4 through R6. Section 12 of the bill transfers sentencing guidelines employees. There's one piece of a bill that transfers sentencing guidelines employees from the classified service to the unclassified service. Let's reverse that, from the unclassified to the classified service. So that's section 12, as well as section 41, which is one of the last sections of the article. Sections 13 and 14 amend the juvenile hearing detention and restraining, is a juvenile detention hearing and restraining reform bill, which is found on R7 and R8. Moving forward to the final piece of major legislation in the bill is the pardon reform bill, which is, I'm sorry, I'm jumping around here. Sections 27 through 37 and 42. Those are found on R22 and R28. And that creates a clemency review commission and makes recommendations to the Board of Pardons on applications for clemency. A couple of other miscellaneous provisions in the bill that I didn't mention in this article is on R28, section 38, prohibits counties from charging jail inmates for mental health calls. That's section 38. R29, there's section 39, creates a task force on felony murder, section 39. R31, there's a task force on collection of charges and related data, which is section 40. And I believe, although skipping around a little bit, I believe I covered all of the articles through the 5 major pieces of legislation and then the miscellaneous provision. Pending any questions, Mr. Chair, I would move on to Article 6.
Yeah, please do, Mr. Diebel.
Okay, the Article 6 and 7 can move through rather quickly. Article 6 is, again, a provision that is a House-only provision, so the side-by-side does not have a Senate provision. And it simply combines the State Advisory Council for Interstate Compact for Juveniles with the Advisory Council on the Interstate Adult Supervision. It takes up many pages because it has to reprint many pages from the statutes and the compacts, which is why it takes up a bit of space, but it accomplishes just that one objective. So pending any questions on Article 6, I can skip ahead to Article 7, which is the Community Supervision Reform article. And this is a topic that was discussed yesterday during the conference committee. This is the Justice investment initiatives proposal to create a new community supervision formula, as well as a committee to implement standards for supervision levels across the various community supervision models, as well as it expands the funding model to include tribal government. Mr. Chair, that concludes the overviews of Articles 5 through 7, and I'd ask that you recognize Mr. Johnson again to cover Articles 9 through 10.
All right, thank you, Mr. Debo. I appreciate the careful walkthrough. And with that, members, we're going to shift into a more focused part of the presentation of the House bill, beginning with the Judiciary Committee highlights. And so I'll defer to our Judiciary Chair, Representative Jamie Becker-Fenn, to get us moving on that.
All right, thank you, Mr. Chair. And I know we are a little short on time, and so I do think the most important use of our time today would be to lift up some voices of folks who are impacted by the work that we do. I also thought it was really important because, you know, there are a lot of things where we have agreement on the judiciary finance items, but one place where we do have some differences is when it comes to additional funding for civil legal services. And so with that, Mr. Chair, I would like to make sure that we have time to hear from the testifiers we have lined up from civil legal services. So if you want to go to those testifiers first, I think that's the best, most important use of our time at this point, Mr. Chair.
Very well. Thank you, Chair Becker-Fenn. And I have three individuals, Dory Rapport, Cheryl Samalinich, and Tashonda Williamson. And I think the order is to hear from Dory Rappaport first. And so if you can come forward, give your name for the record and give us your testimony, we'd appreciate it.
Mr. Chair and members of the committee, good morning. I'm Dory Rappaport. I'm the Executive Director of Legal Aid Service of Northeastern Minnesota. Thank you so much for the opportunity to testify today in support of fully funding civil legal services. I've had an opportunity to speak with some of you, but for those I have not, civil legal aid is turning away 55% of the people that come and ask us for help. And that's because we don't have the staffing and resources to provide services to all the individuals that come to our doors. We historically have underpaid our staff, and currently we have a turnover rate in civil legal services of 36%. The staff salaries is definitely a big reason that we can't keep people, and the 36% is not sustainable and doesn't allow us to help Minnesotans. If we were fully funded and we had the staffing to help every Minnesotan that came in our door, we would be able to do things like ensure that everyone who needs help in a family law case gets the assistance that they need. Right now, because we have limited staff, we have to do things like just provide them with advice or just provide them with assistance with forms. And that's not enough. There's an Iron Range judge that could tell you about a time when there were lawyerless litigants in front of him who were there for a divorce, and they didn't know how to put forward the information they needed to help him make a decision about what was actually in their children's best interest. Without a lawyer, they're not able to ensure that kids for the long run are in the custody of the parent they should be with. All of these family law decisions are challenging, and so you need lawyers to help litigants navigate a system that's not designed for lay people. There are domestic violence victims that have to go to court, and they have to cross-examine their abusers because we don't have enough lawyers to go with them to court. No survivor should have to go to court and be re-traumatized because they don't have a lawyer, and only they can cross-examine their abuser to ensure that they can get an order for protection to protect them going forward. If we were fully funded, we could be there with all the domestic violence survivors. If we were fully funded, we could also continue great innovation that we're doing now. We're coordinating with the courts, and we're able to have staff at housing calendars where we can ensure that homelessness is prevented and that landlords are getting paid. And when we're there, we're able to represent them. If we're not there, these issues are worse. People end up homeless. Landlords don't get paid. Housing isn't protected, and the judicial system sees the inefficiencies when people aren't represented. If we were fully funded, we also could hire staff that want to come work for us. There are lots of people that want to dedicate their lives to working for civil legal aid, and they can't because they know they're not going to be paid enough to pay their bills, have a good quality of life, and pay their student loans. So they have to go and work somewhere else. If we were fully funded, then we could ensure that every person who can't pay for a lawyer could walk into our courthouses across Minnesota and know that they're actually going to get justice, even if they feel like they can't afford it. They deserve justice because everyone deserves equal access to justice, and legal aid can help all those individuals achieve that in our judicial system. Thank you so much for the opportunity to speak today, and we're open for any questions you may have.
Very well. Thank you, Ms. Rappaport. Thank you for joining us today, and thank you for your work. Next, we have Chair Becker-Finn. Next, I show Cheryl Smilanich. Hope I got that right, but I'll gladly be corrected. Ms. Smilanich, please come forward.
Good morning, Mr. Chair and members of the committee, and you were very close in pronouncing my name, so good job on that. I always tell people I married into the name, so even in the family, people have problems pronouncing it. Again, I appreciate the opportunity for you allowing me to testify today. Again, my name is Cheryl Smilanich. I'm a paralegal with Lasnam in the Virginia office, and today I'd just like to share a little bit about what I see every day in our office, and some of it expands on what Dory just mentioned. So we get calls all the time from people needing help with divorces, custody cases, parenting time issues, and obviously, as Dory mentioned, we don't have the staff and resources to represent everybody. So what we've been doing here in our Virginia office, or excuse me, it's throughout Lasnam, but we have family law clinics the first and third Wednesdays of each month, where we are able to have meetings with clients, and due to the pandemic, we're now doing them virtually, but we provide clients with assistance in, how do you fill out these forms so I can file for divorce? How do I prepare these motion papers so I can get custody of my children? How do I fill out these forms so that I'm allowed to have parenting time with my kids? And even though we're not able to represent the client fully, at least we can give them advice and counsel and help them get the forms completed. So one case I recall in particular, a person had contacted us. His child's grandparents were filing for custody of his child, and he obviously was fighting that issue, and he was referred to our family law clinic, again, because we didn't have the staff to provide full representation. At the same time, he also was talking about a divorce. So he was told, well, let's get the custody issue taken care of first and then contact us back when you're ready to file for divorce. So a couple of months after he initially called us, I had contacted him to see how things were going and if he was ready to file, the paperwork for the divorce. At that time, he told me things were so complicated. There had been interveners in his case, and he was just very confused about the whole situation. In addition to the custody case, there was a child support matter going. He was getting notices of hearings. He wasn't sure which case was what hearing, and I could just tell he was very confused about the whole process. He also told me that he was not an educated man, and that when he'd go to these hearings, he felt very intimidated. He said, I don't speak right. I'm not sure what I'm saying is correct. And in addition, he was having problems figuring out, how do I get witness statements filed? How do I get evidence to the court supporting my position? So all of these things, you know, we encounter on a daily basis in our office, and he truly was someone who could have benefited from full representation in his case. In addition, we see clients who, so with the housing cases now, you know, people are struggling to find housing, number one, and then if they have an eviction on their record, that makes it that much more difficult. A lot of times in our housing cases, if an eviction, you know, agreement is reached, then oftentimes the other party agrees to, you know, expunge the eviction. Well, we get clients calling, well, how do I go about getting this eviction expunged? And obviously there's forms to fill out, and so we'll do what we can. We'll, you know, we'll send the forms to the client, here's how you do it. Well, oftentimes we get calls back, well, I'm not sure what I'm doing. So that entails people don't know, what is the caption of the case? Am I the plaintiff? Am I the petitioner? Am I the respondent? Am I the defendant? And then oftentimes too, you know, people, our clients are eligible for fee waivers. So when they file a case with the court, they don't have to pay the court filing fees. But in order to do that, they have to file what's called an affidavit for proceeding in forma pauperis. So what does that mean? You know, so oftentimes our clients are like, well, what form do I use? So really our office sees this on a daily basis, and it is, you know, we're definitely glad to be able to help the people in whatever capacity we're able to help them. But again, we do not have the funding to provide full representation to everybody. The legal system is very complicated for people, just, you know, filling out forms, getting case numbers, you know, even service of process. When you file papers with the court, you have to make sure it's served on the other party. Well, what does service mean? What is service of process? How do I do that? So those kinds of questions are what we get every day. People struggle with that. The legal system is very complicated and confusing for individuals. And, you know, we wish we had this capacity and resources to provide full representation to everybody. And our goal is to, you know, allow people to have access to justice. So again, I thank you for your time, and thank you for allowing me to testify today.
Thank you, Ms. Smilovich, and thank you so much for your work in, up north from us in Virginia, in the area there. The legal process is, in fact, quite complicated, even though for many of us who interact with it, it seems simple. But I think for most citizens, it could certainly be perplexing and can lead to, you know, mistakes that folks don't mean to commit in working the process. Next, we have Tashonda Williamson. If you can come forward, please.
Thank you so much, Mr. Chair, Madam Chair, and other members of the community, or excuse me, other members of this committee. My name is Tashonda Williamson, and I greatly appreciate this opportunity to share with you my experience as a client of legal aid. I do want to just say thank you for allowing me to attend this virtually. This is very traumatizing and triggering for me of what I had experienced. And so I really appreciate being here, and I'm going to try to keep it together here. For a high level just sharing of my story, I was a licensed kinship foster parent who took in my two nieces who were a newborn and infant at the time that were the biological children of my half-sister from my mother's second marriage. And an inter-family fight over the children went forth, which included Hennepin County Child Protection. The children were, they started off with my sister. They received the resources they needed for her to be able to to get what she needed. And the children ended up being removed and returned to me, where at that point the plan was adoption. And my sister's father's side of the family submitted a slanderous letter making accusations, which prompted an investigation. That investigation resulted in no open case. However, the procedures of kinship and licensing required that because there was an investigation, the children had to be immediately removed from my care. The children were ultimately adopted in a closed adoption. And thankfully with that, I'm still to this day in communication with the children as well as their adoptive mother. I didn't know what to do. I'm one that can articulate very well, and still was very confused on the process and what all was happening. And South Smyrnos, you all know it as, helped to navigate the issues with Hennepin County by first accepting to represent me, even though they let me know, it was like 4 different persons I spoke to in regards to the intake that were all, was all informing me that the probability was very low of me winning of that type of case being one, but yet they did accept to represent me. They also provided me exceptional representation to highlight the lack of due process in regards to my constitutional and statutory right, and then also bridging resources and connection towards legal remedy and hopes to make whole from the disparaging impacts to me and my family that still impact us to this day. It is hard to navigate the legal system, and because of that, that's because there's legislative loopholes and agency misinterpretations which perpetuate institutionalized racism. The American legal system allows administrative law to require rigid accountability to Black and Brown constituents, while said system lacks being held accountable for its disparate impacts placed on individuals and families. There is disaggregated data that is evidentiary of these said disparities. And so with representation by legal aid, it helps the process to work better because therefore dissemination of the laws, or the statutes and amendments, as well as give legal definitions with equitable measures and applications to require due process and accountability. My experience has been very traumatic, and I just want to say that it has served as a springboard for me to start my own nonprofit for anti-discrimination and advocacy and dedication to helping others, because I've received an opportunity that most don't, really an opportunity that I should not have needed because I've always been an upstanding, law-abiding citizen. My last point that I would like to make on today, Mr. Chair and others, that if time was reversed and I had to do it all over again, I would wholeheartedly make the same decision. I was the one that initially had called child protection on my sister to give resources to her and to our family, which ultimately led to where it did. But I would endure the slander and persecution all over again because I'd rather have that than to have to live with the regret of something happening to one of those babies and I had not done anything about it. Thank you so much.
Thank you, Ms. Williamson. And let me just say that you are indeed a very powerful articulator of very important issues. Courageous work, but necessary work on your part. I can tell you that both Chair Limmer and I, were physically leaning forward as you were speaking. And that's always, to me, a good sign of a real authentic story that needs to be heard. So thank you for that. Chair Limmer, I'm not sure if you have a question for Ms. Williamson or not, but I certainly would invite you.
Well, thank you, Mr. Chairman. Ms. Williamson, you made a comment that your civil rights were abused or denied. Could you expand on that for me? I'd like to know how that happened.
Ms. Williamson.
Yes, thank you. It's Senator Limmer, correct? I want to make sure
That's
I'm
right.
pronouncing your name correct. All right, thank you so much for your question. And so you were wanting to know how I felt that my civil rights were violated, simply because I did not receive proper due process. I am entitled to, any constituent is entitled to due process. And I basically was treated guilty and had to prove my innocence. And we know that is not the way the law is set. Did that answer your question?
I believe so. Thank you again, Ms. Williamson. I really do appreciate your time
Thank
here
you.
with us today, and much blessings and well wishes in your work, looking out for your family and for others. Chair Becker-Fenn, thank you. Chair Becker-Fenn, that concludes your testimony relative to the civil legal services issues. Is there anything else you wish to add at this point?
Thank you, Mr. Chair. And again, I just wanted to make sure that we took this time at this level to lift up the impact of civil legal services. And the one statistic I did want to just make sure that we all hear is that right now we are currently funded at a point where only 45% of the people who reach out and ask for help get the help that they need. And that's a statewide figure. So that means there are constituents of every single one of us who reach out to legal aid in a time of need, you know, one of the worst points at a person's life, they've reached out for help and are turned away because we simply don't have the resources to provide these services to everybody who needs them. And so I think that, and I just want to thank the testifiers. I think they did a great job of highlighting the types of cases and why this is so important, and the statewide nature of this, and how we can make the whole system work better. Judges, I can tell you as a former judicial law clerk, it is much easier to have folks in front of you from the bench who have attorneys who know how the system works and know all the lingo and know how the process works, as opposed to people who are undergoing, you know, trauma in the moment, trying to, you know, I think especially the point of a domestic violence victim having to do a cross-examination and question their abuser on the stand in public. We don't want that to be the experience of any survivor, and I think that's why these dollars, this is the difference we can make. And so I just appreciate the time to lift this up, and appreciate, you know, I'm on Zoom, but I could tell you are all listening, and I really appreciate that. I think that's one of the most important things we can do as legislators is listen to the public when they have important things to share with us. So thank you, Mr. Chair, for giving us the opportunity to lift this up.
Thank you, Chair Becker-Fenn. And Chair Limmer wishes to make a comment before we move on to Representative Fraser's part of the presentation. Chair Limmer.
Thank you, Mr. Chair. Senator Becker-Fenn, civil law, civil legal gives an opportunity for people of low estate to have access to an attorney at no charge. And I believe that's focused just on civil law cases, is it not? And so it's not criminal, because we would have a public defender for such people that would be needing that type of thing. Just to point a reference, a historical reference, last year our legislature increased civil legal by 23%, 23.6, I believe, but 23% was rather sizable. It was kind of a sizable tip of the hat to the need that we saw. I keep going back to the reference that some of these issues that we're talking about in this bill should probably be taken up during a regular budget year. We have some monies available, but to commit us to a long-term dollar amount in an off-budget year, I get a little nervous. And so how much money is being requested in this request? Is this to fill the whole 100%?
Chair Beckerfin.
Thank you, Mr. Chair. This would get us to 75% of the need. And again, I know it's a big number, but I think that speaks to the long-term inadequacies in how we've funded the system. And I did want to clarify, yes, it is civil legal services, but in order for protection, for example, which is one of the most common orders that is sought by a domestic violence victim, those are actually civil orders and are handled in the civil court process. So yeah, all the family law, civil commitment, accessing benefits, federal benefits, that's another really common area for civil legal services. If you qualify for Social Security and it gets denied, trying to access that federal process without an attorney to help you navigate that is incredibly difficult, if you're trying to appeal to get the benefits that you're entitled to. And, those are all the different areas, as well as housing, which was mentioned before. But yes, it is civil legal services. And yes, it's folks who don't, you'd have to qualify. It's not like just free legal services for anybody. If you have the means, you can hire your own private attorney, but these are for folks who are on the lower end of the income spectrum, which, unfortunately is a lot of people. So, but yeah, I appreciate, that we were able to do some increases for civil legal services last year, but, there's an opportunity here, and hoping we can all keep open minds and hearts as we look at this opportunity that's in front of us.
All right, thank you, Chair Beckerfin. And I do think it's important that we raise the kind of questions that Chair Limmer has raised so we can have the conversation. I do note that you're not creating new demands and new needs as much as I think your committee is responding to present demands and needs. And it sounds like we did some really good work last year, but more good work is needed. That's the proposition on the table before us here today. Thank you for helping us slow down a bit and to focus on this particular part of the House bill. Next, members, we're going to then shift our focus over to public safety. Our original intent was to have that focus on Friday. However, it doesn't sound like we're going to have a quorum on Friday, and so we're going to try to do some justice to important public safety issues before us. And so with that, I'm going to call on Vice Chair of the Public Safety Criminal Justice House Committee, Representative Frazier. Representative Frazier.
Thank you, Mr. Chair. And I will go through some details of House File 4200, and I will try to be brief, considering the time constraints and the fact that we won't meet Friday or Saturday. So thank you for your time here. Just to quickly, what I'm going to discuss and what I'm going to cover is one, there's 6 grant programs in House File 4200. There's also $4 million in grant oversight for this program, and there's pieces of this bill that deal with the accountability and transparency pieces that are vital to the promotion of community crime reporting, as we've heard several people testify to and speak on. That goes from our prosecutors to our law enforcement agents as well. So there are 3 general grants, and anyone can apply for these. They're the body camera grants, the co-responder grants, and the emergency grants. The emergency grants are one-time money. And this is the only resources that can go directly to nonprofits, but also to law enforcement agencies. And it is based on the work and the efforts that the Department of Public Safety has done in the past and undertook last year. We want to get this money out quickly as we are headed into our summer months. We want those resources to be available as soon as possible. There are 3 targeted grants. And these grants will be available to 80 municipalities with the highest crime rates in those particular areas. There is a map that we have in your materials that you can reference. Now, it's in black and white, so I would encourage you to go to the website to look at the colored version to kind of see how the crime rates map out around the state. This was important for us to illustrate in this map form because what it does, it shows the need that we have around the state of Minnesota, not just particularly measured in terms of the metro area, but around our state. We want to make sure we get those resources out there. There's also as part of those 3 grants, there's the local investigatory grants. As you heard from the walkthrough, it provides resources to increase our clearance rates. That grant also allows for bonuses and scholarships for law enforcement, and I know that is something that Senator Limmer has focused on in his bill, and I think we can find some agreement there. It also provides resources for law enforcement support personnel, investigatory training, evidence technology, and among other items. And we move on to the local community policing grants. And the purpose of these grants is to provide funding to boost capacity and promote effective practices. Those grants can also be used for bonuses and scholarships as well. And then finally to the community innovation grants. Now this is a bulk of the resources, and I want to be clear about what these resources are for and where these resources are going, because I think this is where a lot of the attention and the conversation has been around. We call them innovation grants because it's a new way of leaning into and supporting and providing resources for law enforcement and for public safety in our communities. Many of the programs that are listed in the grant that will be eligible for these resources are not necessarily new. Many of these programs and strategies are already being used by our municipalities, our tribal governments, and our counties. But what we're doing is, what's innovative is the way we're putting resources into these programs to ensure that these programs can be done with fidelity, they're sustainable, and that they can be expanded as well. Those programs are reentry programs, victim services programs. We know that our counties and our cities are already doing programs just like this. Homeless assistance programs, very vital. Mobile crisis teams and embedded social programs. Those are becoming more prevalent by the day because what law enforcement tells us that it makes their jobs easier when they don't have to continuously go out to the same calls day in and day out, when they can get someone there to provide resources to individuals to keep them out of those calls for crises. Restorative justice programs. Our prosecutors, our county attorneys are already using these types of programs. We want to be able to expand and give them the resources they need to help use them to make our communities safe. And I talked a bit about the co-responder programs, but those are vitally important. And again, our counties and our cities are seeing how important they are and the impact that they have in keeping their communities safe. Community violence interrupter programs. Those programs are important because those are some of the programs that are being used where we have community members working in tandem with our communities, with our elected officials, and with law enforcement to prevent crime from happening in the first place. And that is what we want to have. It is better to have crimes prevented as opposed to working with someone as they're actually entering the criminal justice process and working through that system. Investing on the front end saves us money on the back end and promotes public safety in our communities. There's also eligibility for blight elimination programs and also programs that provide technical assistance to service providers who are doing the work of creating a better public safety system for everybody in their community. Now, I want to dispel some of the misconceptions that I've heard as we've been working through this process and presenting this bill. As I mentioned before, a bulk of the money does not go directly to nonprofits. And also, the scale of this grant is not new. We already distribute over $50 million of domestic violence grants. What's new is the fact that we're going to lean into some things around that are going to create a better public safety system that we have not done financially, resource-wise, in the past. That is a very innovative thing to do here. Another misconception that I've heard is concerns about accountability for these grants. Now, I want to be very clear here. There is more accountability on this money than any money I think we've ever spent from a legislative perspective. And let me explain. We're building a statistical analysis center. We're requiring reporting and evaluations to every grant. We're hiring employees to perform oversight, and we're having 3 layers of review for these grants: a regional board, a state board, and the Department of Public Safety employees. And ultimately, the commissioner will have to sign off on this. That is a very high level of accountability for these resources. And we think that's important because it is taxpayers' dollars, but we also know it's very important to make sure that we have these resources out there to create the safest communities possible for Minnesotans. And this is what it will take to ensure we are providing proper oversight on every dollar, but also learning from every success or misstep. And lastly, we need to vitally promote community crime reporting. Another misconception that we've heard is what I've heard is many folks complain that police reform is somewhat antithetical to public safety. Well, we recently had the MDHR findings. What we saw in those findings, what it tells us is that there's been a failure at the legislative level to implement the type of accountability and transparency that we need in law enforcement as a state. And when that happens, misconduct occurs, evidence gets tossed out, cases become more difficult to build to get convictions, and cases get thrown out. And what that means for our communities, unfortunately, is that criminals get loose. Communities stop reporting, witnesses stop coming forward, and public safety suffers. That is what this bill is trying to prevent. That is what this bill is trying to ensure does not continue to happen and does not happen anywhere else in this state moving forward. We need to start treating community confidence like it's an intelligence asset. We've heard numerous law enforcement professionals testify to that. Chiefs, sheriffs testify to that. That's what this bill does by getting prosecutors out of the way of licensing boards. Law enforcement at the post board has already moved to vote on some of these processes and some of these requirements and policies. What I hope, Chair Limmer, is that we can work together to help law enforcement as they move forward in their efforts to clean house and create a better public safety system for everybody in this state. Thank you.
All right, thank you, Representative Fraser, for that oversight walkthrough of the framework of the House's provision on public safety innovation, how it works, why it works, how it's being targeted, et cetera. As the second part of this a brief focus on the public safety provisions of the bill, we also want to hear from the Department of Public Safety, and I believe Superintendent Evans will be providing some testimony. Good to see you, Superintendent. Welcome. Please come forward and provide us with your testimony.
Thank you, Mr. Chair and members. My name is Drew Evans. I am the Superintendent at the Minnesota Bureau of Criminal Apprehension. I'd like to begin, Mr. Chair, by thanking you and the House Committee for making multiple investments in the BCA to help support our law enforcement and criminal justice partners as they work to make their communities safer. Commissioner Harrington has asked me to testify on the BCA provisions the committee has asked us to highlight here today. Commissioner Harrington has also submitted a letter on behalf of the Minnesota Department of Public Safety regarding other provisions in the bills and the work that you've been doing, and is happy to provide additional testimony or answer questions on department items the department finds important to take the holistic approach to violence prevention in the state of Minnesota. Again, thank you, Chair Mariani and committee, for funding in your bill things such as the provision to bring accreditation for our law enforcement functions at the BCA, finishing a cybersecurity ask that was partially funded in your work that you did last year that would better position us to protect our data and data systems from nefarious actors, along with policy provisions that are provided in your bill that will help us deliver on our mission in Minnesota. The provision that you've been asked to speak to today is the Violent Crime Reduction Support Initiative that the governor provided in his budget ask. I know I've had the opportunity to speak with some of you about this. I have handouts here today if members would like to see them, and I believe it was sent to Committee Administrator Lundy as well for members should you ask for that. The governor's budget request for the Bureau of Criminal Apprehension to combat the significant rise in violent crime has three main components. A violent crime support unit within our BCA Forensic Science Services that would increase DNA and firearms testing capacity. With the increase in violent crime, our laboratory has experienced approximately a 30% increase in violent crime-related cases, and this support that is provided would be able to provide additional support to our criminal justice partners across Minnesota as they work to process that evidence, identify those who have committed crimes, and clear the innocent as well in that process. Our turnaround time right now is high because of that, and this would allow us to maintain or reduce those turnaround times, in particular for DNA and firearms testing that we are experiencing significant caseloads on right now. The second component of this is analytical support, which would be within our criminal information and operations section. With lower numbers of peace officers across the state, it becomes critically important that we have the ability to provide assistance with criminal intelligence analysts to do work to support our officers, to keep them out on the street, keep our agents out doing the investigations, to ensure smart policing by utilizing information to identify those who wish to commit serious acts of violence in our communities. This function is also critical as we work to track and combat things such as hate crimes, violent ideological extremists, threats to our faith-based institutions, our schools, workplace, and others for those who wish to commit mass violence. As an example for all of you, just since November, we've tracked and responded to 40 different school threats across the state of Minnesota. Many of them are hoaxes, but they obviously create great concern to parents and school districts alike, and every one of them must be treated seriously until confirmed otherwise. We've also screened 27 different threats, what we call threats to life, that we partner with federal partners and local partners when somebody makes a threat of mass violence, and this team is the one that do that work again. The third component of the governor's budget request is a violent crime investigative partnership to provide support to local agencies across the state investigating violent crimes, violent criminal organizations that are committing shootings, homicides, and robberies in our communities across the state. This team would utilize data analysis to take smart policing approaches to address crimes at the request of our local partners and partner the same way the BCA has partnered since 1927 to provide specialized resources and expertise in those communities. The BCA provides those specialized resources and expertise and personnel to provide that targeted assistance, not to take responsibility for local policing, to assist our local partners all across the state as they work to keep their communities safe. We work closely to support those partners. We're all working diligently right now to reduce violent crime. This investment in the governor's budget request for the BCA will allow us to meet the needs and demands that have been currently placed on the BCA, but will also allow for the creation of partnerships that can further all of our resources as we work together collectively as law enforcement to reduce that violence crime that we've been experiencing. Along with Commissioner Harrington, I look forward to continuing to work with all of you as you work on this really important work for Minnesota and all of you working to keep our communities safe. And with that, I'd be happy to answer any questions of the committee.
Very well, thank you, Superintendent. The House, in the House bill, we certainly do affirm the proposition that the state continue to find powerful ways to partner with and support our local law enforcement communities. Everyone knows here that law enforcement work is primarily heavily a local responsibility. Obviously, the state has responsibilities as well. But, you know, it's our locals that often wind up, at least in my opinion, wind up depending on who you are. You know, what kind of tax base you have, what kind of population base, what kind of particular challenges, because every community has its own dynamics. You may or may not have the resources to be able to be effective at providing some critical components for public safety. The House certainly heard the BCA's presentation. We primarily focused our efforts in the House bill in a heavy interest in investing in forensics and science work that can lead, scientist work that can lead to the clearance issues. If we're not clearing cases, you know, we're only compounding public safety. Clearly, the BCA also has some other things that it has asked of us, and I suspect that'll be part of the ongoing conversation here as well. The House also invested in responding to the cyber threat issue. I know you didn't mention that, but it is critically important for sure. And so, you know, we've got a response in the House bill. We don't have a response of that in the Senate bill, but that's what we're here for, is to have a conversation about, you know, what would be areas where we could meet and respond to that. Members, if you can stay right there, Superintendent, this does then conclude the section of the agenda where the House is presenting its bill, and obviously what we did is we did a particular focus in our judiciary area with civil legal services, and then in public safety, particularly ways in which we look to support law enforcement efforts, but also look to advance this multi-tool approach for combating crime and for advancing public safety in an innovative way. So what I'd like to do, members, right now then is to open this up for discussion and conversation, questions, et cetera. And I do note that Senator Bingham has her hand up first. So, Senator, please.
Thank you, Mr. Chair. First, I want to lift up what Chair Becker-Finn said about civil legal. I really can't add much other than I just want to say that during this pandemic over the last couple of years, it is very apparent for the need of these services where it has been, the hardships have been disproportionately impacted in communities of need and lower income disparities. And so we need to address those, and this is one way to do that. So I just wanted to echo what she said. Superintendent, I could not be a more stronger proponent of all $9.8 million that your department needs. There are two things that I feel in this bill that will have a direct, immediate impact on safer communities, which we all deserve, no matter what zip code we live in. The superintendent's proposal and community corrections funding. And you will feel immediate impacts across our state if those two provisions are included in a final bill. So thank you for your advocacy for the needs to solve, resolve, and investigate crimes on behalf of Minnesotans. The partnership that you have with our local government is imperative and important, and you do a great job. So I just wanted to reiterate that I hope that both of those proposals are included in any sort of final budget.
Yeah, thank you, Senator Bingham. Chair Limmer.
Thank you, Mr. Chairman. Superintendent, you made comment in your presentation regarding expanding some of the intelligence capabilities of your agency. How does that differ from the Fusion Center debate that we had last year? The agency requested an expansion for Fusion Center capabilities. It was rather sizable, and at least in the Senate, we had asked that there would be an advisory board made up of not only professionals but civilian experts on data collection, government data collection, and uniquely how it would apply to perhaps the broader collection of information that wasn't quite so specific to a criminal activity. And somehow that got lost last year. And why isn't there an advisory board reference in this legislation?
Superintendent.
Mr. Chair and Chair Limmer, excellent question. So I'll bifurcate the two in terms of what we're asking for in this budget request. One, that criminal intelligence analysts provide significant support, analysis, evaluation of the information that's available when it comes to violent crime. I'll give one example. The little girl, Trinity Addison, that was jumping on a trampoline and was shot in Minneapolis. We provided assistance to the city of Minneapolis in that case. The agent that conducted that case went through and executed nearly 100 search warrants in that case, gathering all types of information to really hone in and identify the individual that was responsible for that shooting. That work would be better provided by criminal intelligence analysts. He was tasked then with analyzing all that evidence, going through that evidence, going through and organizing it, which is really where our criminal intelligence analysts best shine in supporting these criminal investigations. That's where much of this support would be done, and to analyze data that is available already from our partners to identify those individuals that are committing the most crime. That's where this would be focused now, in addition to the things that I talked about in terms of analyzing threats that are coming in, both from the public and others that we would be examining. Is there a criminal nexus? When your question about the Fusion Center often gets muddied in these conversations, but it is really our federal terrorism nexus, the work that they do. It's approximately 7 individuals that are federally funded right now that focus on things such as terrorism and our federal mission to protect Minnesotans from those types of crimes. When it comes to your question about the oversight board that you're referring to, we have addressed that in a couple of different ways. One, in the House provision, there was a provision that was adopted that would provide reporting and significant reporting that we worked with Representative Feist to ensure that it was meaningful reporting and then audit functions of the Fusion Center and the work that we do, and we support that if we have the appropriate resources to conduct that report. Second proponent of that is the proposal to expand the role of the advisory board that's currently on the BCA that focuses on criminal justice information sharing to provide broad advisory role in terms of all of the BCA functions, including reviewing any reports, providing input and advice, and any audits that we conduct. That committee is currently structured, or that advisory board is currently structured in statute to have a very broad swath of individuals, from legislators to criminal justice professionals to members of the public. And so that report would be done in that manner, and then that board would provide the review and advice on any findings that were made related to that and how to conduct those activities.
Thank you, Superintendent Evans. And, you know, Chair Limmer, I do appreciate the question, and I do note, we did mention as we walked through that there is the language on the reporting in the Fusion Center. I want to thank the BCA for working with Representative Feist, you know, to develop, you know, that proposal. And frankly, I want to thank our minority party in the House that facilitated the ability for us to move that forward. So that really was a bipartisan effort in our body. Chair Limmer.
Well, the reason I bring it up, Mr. Chair, is Minnesota has been a long-standing state. I would call it a privacy state, for lack of a better term. We recognize the need to protect our individual citizens' privacy and try to create that critical balance between responding to threat, responding to criminal activity, but at the same time protecting the interests of citizens that sometimes get trapped into that tracking. And we have to be very careful, and that's why issues like advisory boards bring a little comfort to those that are really particularly interested in it. I think they serve a very good purpose, and it keeps everyone a little bit honest. Don't take it as a disparaging term, but it keeps everyone knowledgeable that this state does protect individual privacy, and it's a priority. It has been a priority of this legislature, and it'll only continue if we continue to bring it up. So, and Mr. Chairman, I want to thank you for partnering on a variety of ideas over the years as well. We've had lots of discussions about that type of thing going way back. And so these are the concerns that I always have when we continue to expand that net of data collection, and we'll continue to ask that question. One thing I wanted to bring up is whenever there's an investigation by any investigative unit similar to the BCA, that starts kind of after the criminal act. It doesn't do much to prevent crime. It doesn't do much to react to the immediacy of the threat. And I think that's important to keep that focus in mind as we're having our broader discussion. If there's a threat out in the community that is rising, what can we as a government do to solve that immediate problem that's a safety threat to our citizens? And of course, we need to have adequate resources given to the post-criminal act that would draw that conclusion to a swift and sure criminal justice system that goes after the bad guys that are doing so much damage to our citizens. And and hold them accountable that the system can do. We may differ on what that reaction may be in the future, but nevertheless, it's important to bifurcate the before and the after. And how do we prevent crime? How do we respond to that immediate threat that threatens individuals?
Thank you, Chair Limmer. I couldn't agree with you more. Thank you. And yes, we do have a history of protecting privacy issues in particular, and trying to make sure that we've got the right line, if you will, relative to the power of the state. You and I did some momentous work a decade ago that held up for a decade, but it's one of the highlights of my career here of working with you to make that happen. Senator Matthews.
Thank you, Mr. Chair, and I kind of wanted to piggyback off what Senator Limmer was just asking, because my recollection is that we did not decide to hear this in the Civil Law Committee because there was still some concerns from some of our privacy advocates with just how do we ensure that we're not going to have this turn into mass surveillance on innocent citizens. And so I kind of, maybe Senator Limmer asked in a roundabout way, but I kind of want to be direct, and maybe if you could point to exactly the page number that we're looking at in the bill, if you know. And I'd like an update on, have you been able to get any work done with any of our privacy groups or Mr. Neumeister or the advocates that are here focusing on that? Do you have an update on what you've done there?
Yeah, thank you, Senator Matthews. Let me take the first part of that, and then I'll ask the superintendent to also respond. The vice provision that I mentioned earlier is found in House Section 20 and 23. There's a DPS proposal to expand the purview of an advisory board to also oversee the BCA, which would include the Fusion Center. But I'll stop there and then ask Superintendent Evans to also respond.
Which article is that in, Mr. Chair?
My staff tells me it's in Section 20, actually Article 2, Sections 20 and 23.
Thank you.
Yes, of course. Superintendent Evans.
Thank you, Mr. Chair, and thank you, Senator Matthews. Excellent questions in terms of what you're asking in terms of this. The information that was provided, the short answer is yes. We have made significant progress with groups such as Minkoji and Mr. Neumeister, who I have a fun back and forth relationship with, and they certainly got this provision to that. We took the language that was presented by them, and then we worked with Representative Feist to ensure that the language actually is representative of what actually occurs with that work. So the gist of almost everything that was requested of them is in there in that reporting. And so, yes, we've made significant progress with those who have privacy interests. I want to be really clear. I agree with everything all of you are saying in terms of protecting the privacy of Minnesotans, and that mass surveillance should never occur of any of our citizens. We adhere to a very strong privacy policy that I'm happy to provide a copy of to everybody. What this reporting does and what the advisory board and what the auditing does is ensure, as Chair Limmer noted, that there's some level of transparency, sunshine, and accountability built into this to ensure that the employees and staff that we have working diligently every day to protect Minnesotans are following that policy, are staying within the confines of the law, are not doing mass surveillance on any citizens, but they're working to disrupt and prevent violent acts and provide assistance in criminal investigations when needed. So as you can see, it does reporting from everything from the suspicious activity reporting that we do to requests for information that are provided through that group to additional information about the operations of that section every day. So my conversations and I've recently had with people such as Mr. Neumeister, I think it feels like we're in a very good place with this reporting moving forward to provide some of that transparency and accountability you're looking for.
Well, and again, Superintendent, I do appreciate your working with him and others on that. I will add, and Senator Matthews, I suspect the superintendent may not like me to say this, but, one of the reasons why we did limit in the House, the BCA funding request was to heavily focus on forensics and analysis, and less on the investigation proposal that they had, which, arguably marches us into some of the concerns that we may have. I know the superintendent doesn't totally agree with that, and I respect that. But I'm just sharing, where we were feeling sensitive about where we needed to draw some lines, and hopefully we can continue this conversation. We can get a point of comfort, relative to all three bodies here. Senator Matthews.
Thank you, Mr. Chair. And if I'm reading this correctly, this advisory group for oversight is going to be added to an already existing advisory group. This will be added duties, if I'm reading section 22 correctly. Maybe if Mr. Evans could speak to that. And I'm scrolling through the membership here quickly, and it appears to be a lot of government officials and just a handful of public members. I see maybe a few appointed by the governor, one by the House, one by the Senate. So maybe if you could speak to who's on this and how do we know that those folks will be providing sufficient oversight?
Superintendent Evans.
Mr. Chair and Senator Matthews, this is correct. We have worked with this board and they agree to take on these additional duties. If you all approve this language, this was a proposal that we have brought forward in terms of expanding the duties of the advisory board. I believe there's 4 public members. I think that's certainly to the will of all of you, but that's a fairly significant number compared to a lot of boards, task forces, and oversight committees that I sit on and serve on right now. So I think it'd be representative well in terms of the overall membership. This was membership that was contemplated previously by both your bodies in past to provide oversight advisory work to criminal justice information sharing. So it's already in many ways in contemplation with the types of activities that would be done by the BCA already. So that's why we stuck with that current membership from there. And just to be clear, as you're looking through the language, that's the advisory board, but then we have a separate provision that provides that report, which would now fall under the purview of this advisory board. So that report is very specific and prescriptive as to what we would do, and the language in the advisory board would bring that in. It's a public meeting format like any other public meeting that would be available with minutes and all the materials, and certainly would hold us accountable in the sense that advice from that board, if we don't follow it, we better have a very good reason for it, or I certainly believe we'll be having a conversation with all of you about it.
Senator Matthews.
Mr. Chair, thank you. So I will keep contemplating this issue, but I believe this information is very helpful. So thank you.
Thank you, Senator Matthews. And obviously the conference committee is a good place to also for us to bring in language of betters, whatever is in front of us. Members, I do want to move us forward in the agenda. The last part of the agenda, as I presaged. Oh, thank you, Superintendent Evans. Appreciate that. Yesterday was to begin taking some good steps to building a bill. We do have to do that. We have to have conversations and understand each other, and that's critically important for the work that we're tasked with. And in the end, it is about building a common bill. So the House has identified 5 provisions that exist in the Senate proposals that we want to put forward today for a vote for us to move. We think it could demonstrate really good faith, to the public of our seriousness of building a proper and good response to public safety, corrections, and judiciary needs in our state. We have one provision regarding the retention of video and audio of people who have been detained. And so I'm looking for members in the conference committee that would be willing to move that forward for adoption at this moment. Senator Lance.
Thank you, Mr. Chairman and members. This was a provision that I brought to the Senate bill as we were preparing our final package to pass. And the Senate Judiciary Committee adopted it as an amendment. What it does is it, first of all, I'll tell you, it can be found on lines 60.26 to 60.32. So on the side-by-sides, it's in Article 2, page R63. So I'll give members a moment to catch up to me on that. Mr. Chairman, what the language does is it requires that law enforcement agency needs to retain audio and video recordings that they make during a custodial interview, booking, or implied consent or breath testing proceeding for at least 60 days from the date of recording or until all criminal proceedings relating to the person recorded are complete, whichever period is longer. The genesis for this was actually a letter that a colleague of mine who does criminal defense work received from a prosecuting attorney's office who informed her that detention and implied consent videos are only available for 30 days from the date of the offense. I'm quite aware that many times people don't hire lawyers that quickly or get into court on their first appearance that quickly. And if this retention period were the case, they would never be able to access important recorded information about their case, which might potentially include valuable information for their defense. Frankly, it might also, and probably more likely actually, contains information that would benefit the prosecution more than the defense would. In my experience, it certainly ends factual disputes in terms of the recollection of defendants often by pointing out, well, here it's on video and it doesn't say it doesn't show what you think it might have shown, and it ends up removing contested hearings or expediting the resolution of cases that way. So it probably benefits the prosecution more than the defense to hang on to these videos. But the fact is a 30-day retention period is just too short to have practical benefit for the criminal justice system. And we narrowly targeted this, so it's not all retention, or it's not all videos that are conducted in the jail as a matter of routine that need to be kept forever. It's just focused on these particular types of videos that would end up being relevant to any future criminal proceeding. So it's a matter of due process, a matter of having evidence available to all parties involved. The Judiciary Committee in the Senate thought it was a valuable provision and added it to our bill, and I would ask that the House concur in that. And so I think what I will do at this point is move the Senate language on lines 60.26 to 60.32 and ask that this conference committee adopt that language.
Very well, members. The motion is before us by Senator Latz, as just stated. And I can respond for myself as chair of the House Conference Committee that I'm comfortable with adoption of this language, but I would certainly defer to, not defer, but I would also turn to any of our House members to see if they're either similarly comfortable or not comfortable moving, and then it would be appropriate for us to move to a vote. Representative Johnson. Okay, I will. Representative Johnson.
Chair, I'm surprised that this is in here. I'm surprised that a department would not have that information. I've worked many cases, done many interviews, custodial especially custodial and implied consent. The recordings during the breath testing information. That all goes into the case file. It goes into the case file and is in with the case file and is sent to the, whether it's the city attorney or the county attorney, and they should have all that information there. I don't know why it would be disposed of. I don't believe it should be. And if any department is disposing of this information, if it's an interview or not, I do have a problem with that because that is part, like I say, that's part of the case file and it needs to be with it.
Very well, thank you, Representative Johnson. And just so I'm doing this properly, my staff informs me that to state on the record, as the gavel here, that the motion by Senator Latz is that we adopt the Senate language in Article 2, Section 44, found on lines 60.26 to 60.32. Very well, I see a nod there, so that
So
is
moved, Mr.
very
Chairman.
well. That is the motion before us. Discussion, Chair Limmer.
Let me get my mic on. There it is. Too many switches. I don't believe there was a cost to this, Senator Latz. Do you recall?
Senator Latz.
Mr. Chairman, I'm not aware that there would be any cost.
I would
assume
agree with
there's
that.
some minimal cost to retaining data.
Yeah, the reason I bring it up is that
That'd be a
I really
local-
haven't been given any authorization from leadership on any spending authorization at all yet. And I just wanted to bring that up for our general, broader discussion. But while we're moving amendments, I would like to amend the amendment. And I would move to amend the fentanyl provision in Article 4 of the Senate language to be included. And that's on Article 4, Senate language. And I'll ask for a roll call vote, Mr. Chair.
Very well, Representative, or rather, Senator Limmer moves to amend the Latz amendment.
Mr. Chair, I have some additional information.
Okay, but I want to make sure I get this technically correct, so I'm going to ask staff to help me word what the amendment to the amendment, how that should be worded. I think it'd be appropriate to have Senate staff to do that, yeah. Mr., is it Backus?
Mr. Backus.
Mr. Backus, please, sir.
Mr. Chair and members, I think essentially the way Senator Limmer worded it would be fine. It would be to amend the amendment by adding the motion that in addition to that one provision, that Senate Article 4, which is the fentanyl article, be added as well. And just for House members, if you don't have the Senate bill handy, it is also in Article 4 of the revisor side-by-side, the right-hand side, which is the Senate side, sections 1 to 7 on page R2 to R10.
Okay, well, thank you, Mr. Backus. I don't know if you're the appropriate Senate staff to ask this question, but given Chairman Limmer's concern of moving provisions that have a cost before us, because anyway, expressing that concern, is there a cost related to this particular provision?
I'm glad you asked that,
Chair Limmer.
Mr. Chair. It's the one article that I have been given authorization. Hey, this is bite-sized meal. I spoke with our finance chair, Senator Rosen. She's confirmed to give permission to our committee spend $9,000 in fiscal year '23 with tails of $40,000 for fentanyl. Having said that, this provision establishes the same weight thresholds and penalties for the sale or possession of fentanyl as currently applies to heroin. And just so everyone is aware. And so I'll hold for any other discussion. I may want to add, though, that fentanyl is really becoming quite a scourge across the country, and Minnesota is not any stranger to that as well. Recent arrests and seizures of fentanyl is growing to the point of having sizable volume amounts in these arrests. And it's not, there has been some arrests in Minnesota, but if you look at some of the interstate highway connections around the country, it's just unbelievable that the amount and the danger to literally millions of people. In particular, this fentanyl issue is ravaging populations in our minority communities at record numbers. And I think it's high time that the legislature addresses this issue and puts it into law.
Mr. Chairman?
Chairman Limmer, I think we've uncovered the secret to finishing this conference committee in a short period of time, which is for us to get that same phone number that you've accessed with your colleague, the finance chair over in the Senate. That certainly helps. You know, members, two things. One is the House attempt here is a good faith effort to have us begin where there is broad agreement. And as you all know, when I opened up my comments yesterday and today, I keep emphasizing our duty to find that common ground. And I believe that it is here powerfully. And I believe that public safety deserves nothing less than that. The provision before us, amendment to amendment, is a legitimate issue. It's not an issue, quite frankly, where there is common ground. And I suppose you can get us on a vote to say that, you know, we don't have common ground on that. I do want to inform the Senate that we had a good, at least hour debate on the floor of the House 2 weeks ago on this very provision. The minority party offered essentially the language that is being offered right now. I moved at that point to amend that language to meet the minority halfway, to focus on making sure that we were applying appropriate consequences to those who are profiting from the sale of fentanyl, and not to continue to victimize those who are addicted to fentanyl, which is essentially what this possession element would have before us. Members, I suppose I could amend to amend, you know, today, you know, with that again, but I think, you know, the point is being made here. And the point, quite frankly, is that we should be agreeing right now on those things that we can agree on, and we should continue the very fair debate on those areas that we don't have total agreement on. And this is clearly one of those, and I'll totally own that. But the whole point here is to build a bill inside of the week and a half that remains before us in this legislative session to get our work done and make sure that we're delivering the public safety system and the correction system that the people of Minnesota badly wants. So I'm going to encourage members to vote no on the amendment to amend. A roll call has been called for, and we'll take it from there in terms of what the next motion is. And so now, who's the clerk that takes the LA? Okay. Representative Johnson, I want to move us to a vote. We have a half hour yet left. We still have 4 others left. But sir, I will defer to you very briefly.
Chair Mariani, I'm going to speak in support of this amendment. For those of you who don't know, a little pack of Sweet and Low that you put in your coffee has enough fentanyl in it to kill 15 people. Less than a month ago, at the Minneapolis International Airport, they seized 2 pounds of fentanyl. It is here, it's deadly, it's killing a lot of people. Just over an hour ago, the Wall Street Journal headline came out, breaking news. Drug overdose deaths reached record high last year, topping 100,000. For the first time, as illicit forms of fentanyl spread across this country. Fentanyl is very deadly. We need to get our hands on it. We've been seeing this coming, for those of us in law enforcement, for a few years. I've been doing my best to try to start getting people talking about it, coming up with a plan. We need to get on top of it now. Representative Mariani, what your amendment did on the House floor stripped out the possibility of a court ordering a person, instead of going to jail for the possession and use of it, to getting them their help.
It's not true.
The only reason my brother received help for his alcohol addiction was because of the DWI. And without the courts getting involved in ordering treatment, these people will not, and they will die, especially with the fentanyl issue. So please vote in favor of this amendment. It is very important to save lives of people all across the state. Thank you.
Thank you, Representative Johnson. Members, are we ready for a vote? The clerk will take a vote on the amendment, to the amendment made by Chairman Limmer. And we'll need a clerk to do that.
Chair Mariani?
No.
Chair Becker-Finn?
No.
Representative Mueller?
No.
Representative Frazier?
No.
Representative Johnson?
Aye.
Senator Limmer?
Yes.
Senator Osmic?
Yes.
Senator Matthews?
Yes.
Senator Latz?
Yes.
Senator Bingham?
Yes.
Is that everyone? Yes. Okay. That is 6 ayes and 4 nays.
I'm sorry. Indeed. All right, very well. All right, members, I'm used to chairing regular committees and not conference committees. So we've got to have a majority of members of both bodies in order to pass provisions. So on a vote of 4 to 6 with 4 House members voting no, 1 House member voting yes, and 5 House members voting yes, the motion does not pass. So the motion, the Latz amendment, oh, I suppose I should do this. The Latz amendment is before us. Senator Latz.
Well, Mr. Chairman, I guess I'm going to ask for a little bit of transparency here from our chair, Senator Limmer. This is the Senate position, and I would hope that we could agree as the Senate side to vote in favor of the Senate position on what I think is a non-controversial piece. I'm certainly interested in re-engaging down the road on the fentanyl provisions and see if we can find some common ground there to put something important into law. But in the interest of taking some small steps forward here and starting to build a bill that contains some non-controversial provisions, I'd ask if Senator Limmer would agree that we can, that he will support this amendment.
Mr. Chairman.
Chairman Limmer.
Mr. Chairman, Senator Latz, I'm glad you asked me that question. I was hoping to get ahead of you on it. I see that we have 4 or 5 provisions that the House wants us to consider, despite the fact that they look as though they're Senate provisions. I had really hoped that we would have had a little bit more meat on the plate as far as a proposal, especially with the short terms of days left in this session. Taking individual bites like this really doesn't give me a lot of perspective on how this bill is actually going to, how to visualize what this event is going to be. 4 or 5 minor amendments, although they're Senate provisions, doesn't give me that comfort. Certainly, and I've already made mention of the fact that we haven't gotten any authorization for any more spending other than just that fentanyl provision. So we have a long way to go if we're going to take little bites out of this every day. I was hoping to have a little bit larger perspective, lay more cards on the table. Matter of fact, I think I'm repeating the very same question that we had last year in conference committee when the same tactic was being used. On this, it's very tempting to accept this language, provided that the House is in agreement with it. But there'll be other amendments to the amendments coming up. And so I'm hoping to build this a little faster. But Senator Latz, for the time being, I would recommend our committee to vote no on your provision. Maybe we can get back to it later.
Mr. Chairman,
Senator Latz.
I'm going to confess to a great deal of disappointment on that approach, because last year, that very same approach resulted in a bunch of small provisions like this never being adopted. They just were never adopted. Provisions that both sides would have agreed to had they come to a vote in a conference committee, because the insistence was, let's focus only on the top level, big ticket, controversial ones. And we never got to the small ones. And in fact, the excuse for not getting to the small ones turned out to be, well, they're never high enough priority on the other side, therefore we're just not going to deal with it yet. And understandably, these small things are not high enough priority to be, you know, the top 5 that either side is going to make sure get through the process. But we're simply not going to have enough time to go through the process and fight over every amendment with a potentially controversial amendment to an amendment. And I can tell the public right now, if this is the route that we're going to take, we're going to end up with a whole bunch of stuff that the Senate has adopted, let alone non-controversial things that the House might have in their side, never becoming law, because the process is going to fail it. And so it was my hope that at least we could bite off a couple of small things without making controversy. We could have been done with this and probably 2 or 3 other amendments in however long we've discussed this. And we'd have some common ground to work off of, which I think would be beneficial in the long run for the possibility of coming out with a conference committee report. And we know time is limited. So I guess we can continue to have the procedural back and forth, and we can keep track of how many amendments on the Senate side were adopted and how many from the House were adopted. And, well, we took 4 of theirs, but they only took 3 of ours, so we're not going to take any more. Even if it's good stuff and we'd agree it was good policy, we're not going to take it. That kind of positional bargaining leaves an awful lot of good law unacceptable. So I'm not going to try to force the Senate to vote in favor of the Senate's own position, because it doesn't fit within the tactical negotiation strategy of our chairman. But I sure hope this does not bode what the rest of our conference committee is going to be like, because it's going to drive everything underground. It's going to end up at 2 a.m. with exchanges of written proposals and counting numbers on each side for each provision. And we'll end up with a lot of good stuff that doesn't become law, because the process will have failed it with a week and a half to go in session, and we're being only in our 2nd conference committee meeting. So I'm going to withdraw my amendment.
Representative Latz withdraws his amendment. There is a provision that the House wishes to offer. It's the GPS tracking for stolen vehicles. Is there a maker of the motion?
Yes, that would be me. So moved, Mr. Chair.
Very well. Representative Mueller moves that we adopt language from the House bill, which mirrors the language in Senate File 3329 as it was amended in committee. Representative Mueller moves to adopt Article 2 of the side-by-side, page R64, House language on the left side, Section 44, lines 65.19 to 66.3. Representative Mueller.
Thank you, Mr. Chair. Yes, that is my motion, and this is a Senator Johnson bill. I believe there were a couple different committee hearings in the Senate on this. It was also heard in a couple of different committees in the House. It has been moving with broad bipartisan support. And this comes out of something that our law enforcement tells us they need to address carjackers, particularly those who are fleeing from law enforcement and leading to high-speed, dangerous crashes, endangering public safety, endangering officers who are chasing these cars. And ultimately, if these high-speed chases are called off, that means the potential loss of evidence to be able to prosecute and hold these offenders accountable. As this bill has moved through the process, we've had a lot of input from different stakeholders who've really helped us craft this language and narrowly tailor it to address the issue here that we're trying to address with being able to track, law enforcement being able to put these GPS trackers on these stolen cars as they're fleeing. They actually have technology now to be able to launch trackers onto a car, and then they can follow that car via technology rather than having to engage in these high-speed chases. So that is my motion, Mr. Chair, and I would ask for a roll call on this vote.
Very well. There's a roll call asked for the Mulder motion discussion. Senator Matthews.
Mr. Chair, thank you. Representative Mueller, I have a question for you on the provision. And this, Mr. Chair, this goes to why it was a little difficult to get the list of what we wanted to vote for in the 906 email, because this bill was not a bill I supported in committee. I told Senator Johnson that. I discussed this with him several times along the way. He is planning on trying to track it separately right now, I believe, and trying to work on getting it scheduled for a standalone vote on the Senate floor, which was my preference for it when we discussed it in committee. And so I'm wondering if Representative Mueller would answer how this House language, if she knows whether or not how this compares to where the Senate bill left our committee. I voted no on it as it left our committee, but I'm wondering if you could explain if it's the same language or if there are differences to it.
Representative Mueller, if you
Yeah.
could explain the Senate provision.
Mr. Chair and Senator, we matched up the Senate language in our bill, so after your last amendment, we made sure that our language matches yours. So currently, they match.
Senator Matthews.
Thank you, Mr. Chair. So I've struggled with this concept. I mean, this is what we're facing in our technology era of just because we can doesn't always mean we should. And I'm not sure if this provision was properly identified as an easy, low-hanging fruit that we could just adopt into this. I'll defer to Senator Limmer for if he has any views on it, but I'm going to take the same position that I had in committee, and I know I've been working on this piece. I've been listening. I've been working with some of our privacy folks on the Senate side with it, but I'm not there yet, and I'm not comfortable with this provision, and I think it should probably travel separately rather than be included in this omnibus.
Very well. Chair Becker-Finn.
Thank you, Mr. Chair, and a couple things. I just wanted to highlight again, I don't think we can say it enough. One of the things that helps prevent crime from happening in the first place is the certainty of being caught. And this provision speaks directly to that. And I would hope that this, as we're all concerned about carjackings. I think that's something that everybody on this committee wants to see addressed this year. All of our communities are struggling with that. And this is one of those provisions where I can speak to. It was very much vetted by our data folks on the House side. And, I think the current language that matches the Senate is good language. And I just want to also point out that it can't be both things. It can't be both this is a good bill that we should move as a standalone bill, and also this isn't worthy of being in a conference committee. I think we're all familiar with belt and suspenders. Important things that need to happen to keep our community safe. We could be trying to get them moving forward in multiple ways, and to highlight also what Senator Latz referenced. Anything we can move forward right now. I don't see why we wouldn't. We've got what, 10 days, 11, 12 days left of session. If this is a thing we can move forward today that makes our community safer and helps us address the issues with carjackings, I don't know why we wouldn't move it forward. So I thank my vice chair, Vice Chair Mueller, for her work on this throughout session to get this bill in a good place and get this language in a good place. I would hope that we can all support it.
Very well, thank you, Chair Becker. Representative Mueller.
Yeah, thank you, Mr. Chair. And just to point out the narrowing that we've done, if you look at the language, and some of this came from talking with ACLU to address their initial concerns. So these tracking devices, the maximum they can be placed on the car is 24 hours. It also it's limited to vehicles that are reported to law enforcement as stolen. And then following the Senate's lead, we added the vehicle must be occupied. So we wanted to make sure that they weren't putting these tracking devices on parked cars. So we really did hear the concerns about people with, privacy concerns. I share those concerns, and that's why we added that language. I believe we brought the ACLU to neutral on this. And so anyway, just wanted to point that out, Mr. Chair. Thank you.
Thank you, Representative Mueller. Senator Bingham.
Thank you, Mr. Chair, and I want to speak in support of this amendment. It has been a lot of work in both bodies. Senator Johnson has done a tremendous job of bringing folks together. I think you'll recall that this was the hearing where he was having to testify in another hearing, and I got to present because I'm a co-author on it. The folks out in the audience here and watching online, they're counting on us to do things to help them. We have got a lot of stakeholders out here in the audience, and they're expecting us to get our work done. And it's going to take compromise. It's going to take negotiation. It's going to take humility and empathy to do this. And this is one step in a tool that law enforcement needs to be able to, as Chair Becker-Finn said, deter crime from happening because of the fear of being caught. So this is good policy. It's been very thoroughly vetted. And I know it's a tool that law enforcement needs, so I would encourage folks to vote yes on the amendment.
Senator Latz.
Mr. Chairman, I wonder if Representative Mueller would answer a question for this, since I know she worked very hard in the House on this language.
Senator Latz.
Mr. Chairman, Representative Mueller, as I read it, I don't think that this would authorize the use of these tracking devices in a case where an individual is fleeing, is felony fleeing in a motor vehicle. Am I reading it wrong, or is there some provision to allow tracking devices under those circumstances, or is it only if a vehicle's been reported stolen?
Representative Mueller.
Mr. Chair, Senator Latz, it's for motor vehicles that have been reported stolen, but it would be those that are fleeing from law enforcement. So it wouldn't just be, any fleeing case, they'd have to be reported as stolen.
Senator Latz.
So, Mr. Chairman, if an officer tries to conduct a traffic stop and the vehicle takes off, and the officer has a choice, either engage in a chase of 100 miles an hour through a residential neighborhood or not engage in the chase at all, they would not have the option under this provision then of trying to attach a tracking device and then calling off the chase?
Yeah.
Representative Mueller.
Mr. Chair, Senator Latz, that's right, and I'm aware you tried to substantially broaden the language of this bill in the Senate. The advocates of the bill, the law enforcement officials who advocated for this, did not want that. I'm at this point opposed to broadening it in that fashion as well, because that raises a whole lot of other privacy concerns. This is really narrowly tailored to fit those carjacking scenarios that we're seeing right now, happening right now. And that's one reason why we also made this section effective the day following final enactment. Now, if this works out well in those circumstances and we want to come back in future years and broaden it to include those other situations that you're talking about, we certainly can do that. But as I recall from watching that Senate hearing too, some of the privacy advocates had grave concern about expanding it in that fashion.
Members, Chair Limmer has just informed me that the Senate is requiring them on the floor by noon. And so with that, I'm going to move forward with a vote on the proposal before us. The clerk will take the roll on the amendment, on the motion before us.
Chair Mariani,
Yes.
Chair Becker-Finn,
Aye.
Representative Mueller,
Aye.
Representative Frazier,
Aye.
Representative Johnson,
Aye.
Senator Limmer,
Aye.
Senator Osmick,
No.
Senator Matthews,
No.
Senator Latz,
Yes.
Senator Bingham.
Yes?
The House votes 5 ayes and 0 nays, and the Senate votes 3 ayes and 2 nays.
Very well, the motion prevails. Members, we have the beginning of a bill. And we also have our chair from the Senate who has left, Senator Bingham.
Thank you, Mr. Chair. Mr. Chair, is it your intention that we would come back this afternoon? Or?
I would love to do that. There's so many weird rules nowadays, so let's do this. Let's go to recess. That at least provides the opportunity for that to happen. So the conference committee for today stands in recess. Thank you.